Hi everyone, Dave Sugden of Evidence at Trial. Today we're going to talk about the challenge of witnesses with faulty memories. What do we do if it's either our witness, an adverse witness, and they can't recall certain facts we need to get admitted into evidence? A lot of times this happens either in deposition or it happens at trial, and we'll have some document that will do one of two things. It may refresh the witness's memory, or regardless of whether it's refreshed, it actually says the information we want admitted into evidence. And so, is it a past recollection recorded? How do we do? And this is an area we see lawyers often get confused, so let's clear that up now. Let's suppose we have a witness and we're trying to establish what he or she was doing on May 8th, 2022. And we ask the witness, and the answer is, I have no idea. I don't recall. We then show the witness this screenshot, and all of a sudden, it floods a number of memories coming back. Oh, I recall that. I was at the Lakers game. And then not only does it remind me of the Lakers game, I now remember who I saw, where I went to dinner. So even though this says nothing about the content of what this witness did, it refreshes his or her memory. What if we have another document that records a number of things that happened on May 8th, 2022? And the person says, I've seen this document and I still can't remember what I did, but when I wrote this, I was telling the truth. And when I wrote this, it was accurate. What do we do there? Is this document admitted? Is the other one admitted? Let's look at that now. Again, whenever we're talking about evidence questions, we want to go through this methodology. Before we even talk about, is this a past recollection recorded, always go through the foundational questions of, is it relevant? Is there a foundation? But here, we're talking about hearsay, and specifically the occasion where a witness says, I'm looking at a document, and looking at that document doesn't refresh my memory, but I can tell you when I created this document, I was telling the truth. I was being honest. We then go to the past recollection recorded exception to the hearsay rule. We see that in California in Evidence Code section 1237. In the federal rules, we're looking at 803 subdivision 5. And they essentially say the same thing, and I've broken it into a working rule so that we can all understand it. First is the statement is otherwise admissible. What does that mean? Again, we're talking about the threshold questions for any evidence question. It's relevant. There's a foundation. And so think of the document as, if this document was a witness speaking, would that testimony be admissible? Once there, we then say insufficient present recollection. What does that mean? We have to establish with this witness, do you remember what you did on May 8th, 2022? No, I don't. Look at this document. Do you recognize this document? Yes, I do. As you go through the document, do you now remember what you did? No, I don't. The person still, after seeing the document, doesn't have a sufficient recollection. So then we look at, what does the statement actually contain? And so it has to be made when the person's memory was fresh. And so it can't be down the road where the person's remembering something with a fuzzy memory and there's not good testimony that, look, I wrote this document when it was fresh in my mind. In terms of the distance in time, how soon does this document have to be created? There's no bright line rule. For example, there's a case, People versus Cowan, where a detective was interviewing a witness to a crime, and that crime took place 3 months earlier. And as the witness is talking, and according to this witness telling the truth, the detective is writing down what this witness says, even though it's 3 months later. The court said, look, there's no bright line rule, and so long as the witness can provide some evidence that his or her memory is fresh, we should be okay. We then look at how was the document made? Was it made by the witness? In other words, the person's writing down either by himself or herself exactly what happened, or at the witness's direction. You see that a lot with medical records, where a doctor will be making a bunch of observations and someone else will be writing for that doctor. The other is, or another person recording the witness's statement. That's what we saw in the Cowan case, where there's a witness talking and the detective is writing down what the witness is saying. Then is the witness says it's true. In other words, the witness is saying, hey, look, what I wrote down or what I told the person to write down or what the person recorded, I was telling the truth at a time where my memory was fresh. It's then authenticated and read. Key point, it's read. It's not admitted into evidence. And so when we have this past recollection document, it's read into the record, not admitted. What about that screenshot that we saw at the earlier slide in this presentation? Is that admitted? And it's not, and yet what we see in trial all the time is it being handled wrong. Here's just a sample of examination we see in cases all the time, where there's a question by the attorney, do you recall whether you attended a meeting with Ms. Jones on July 1st, 2018? No, I don't recall. Do you recognize Exhibit 1? Yes, this looks like an email I sent to Ms. Jones on July 1st, 2018. Let's stop there. So we have a witness that doesn't have a present memory of what he or she did on July 1st, and then she authenticates an email. The lawyer then says, does this refresh your recollection as to whether you attended a meeting with Ms. Jones on that date? And the witness says, oh, I see that I wrote, nice chatting with you at today's meeting. And then the question then is, Your Honor, I request that Exhibit 1 be admitted into evidence. Any objection? No objection. This is all wrong. And the reason why it's wrong is because the question, does this refresh your recollection as to whether you attended a meeting, we don't get a responsive answer. What we get is the witness essentially regurgitating what the email says. And you see witnesses do that all the time, where it's unclear whether or not their memory is refreshed, but looking at email, they say, oh, yeah, it says here, I went to this meeting. If this is a concern in the trial, as the opposing attorney, you have to object and say, objection, move to strike, non-responsive, because otherwise this evidence is in. The way this has to be handled is the witness has to answer whether or not, does this refresh your memory? Yes or no? And because this is handled so improperly so often, a lot of times judges will actually step in and say, stop, Mr. or Ms. Witness, by looking at this, is your memory refreshed? And if they say no, they have to move on. If the witness says yes, they in essence set it aside and then say, okay, what is your memory as to what happened on July 1st, 2018? After looking at that, they have to in essence say, well, I now recall that I did attend this meeting. It's fairly mechanical, but when facts matter in trial, you have to understand this rule. And by the way, just because the document refreshes the person's memory does not mean it's admitted. But can it be? Yes, sometimes. And who can admit it? The adverse party. And so, for example, going back to my screenshot, whenever there is a document that is used to refresh a witness's memory, the adverse party has a couple options. And we see that in California Evidence Code Section 771 and in the Federal Rules of Evidence 612. And what that says is if another witness that's brought by the adverse party uses a writing to refresh that witness's memory, it's not admitted, but what the adverse party can do is get the document, inspect it, cross-examine the witness on it, and admit relevant portions. And so it's the adverse party. And so, for example, going back to my screenshot, if the person says, oh, my memory is refreshed. I went to a Lakers game. I went to dinner. I saw so-and-so. Hey! If I'm the adverse party, I can use this document and have it admitted. And the reason why I would do so is I would say, this document says nothing about dinner, says nothing about who you saw. It just talks about you going to the Staples Center. In other words, showing that this document doesn't exactly corroborate the testimony the jury just heard. So that is, in a nutshell, the difference between a refreshed recollection or a past recollection recorded. I hope this was helpful. This is essentially the rules as to what they are. If you want to understand the tactics and how to use these as weapons, I encourage you to go to evidenceattrial.com and look at our online courses. Also, if this was helpful, subscribe to our YouTube channel, like, subscribe, leave a comment. Thanks for watching.